All right, so we are recording. This is the August 27th meeting of the working group for the civil commitment performance standards. I think since I'm going to be taking over these groups, I am going to defer a bit during the first bit, if it's all right to you all and Kevin, just to make sure I'm caught up on where we are as far as working on these go. I know we've got a bit of a working draft where we've kind of, and I will go ahead and share that screen. Where we've been going through kind of what we think the best practices ought to be. Kevin, is that where we left off?
I mean, I think it's been a pretty long while since the last time we had a real substantive discussion because there's been a lot of scheduling issues. So I think the last real substantive discussion we had mostly had to just do with contact and communication and preparation. So.
Okay. So then I suppose I will pitch to the four of you. Where do we want to go from here? We've got the contact stuff in a place where we could start drafting some standards around that. Do we want to move on to the actual, well, not actual, I suppose, but the substantive casework or hearings, or where from here? And I apologize, I'm going to lean on you guys a lot. I have never done a civil commitment before, so.
Could you remind us what our end goal should look like?
Sure. So our end goal is to come up with two things. One is a base minimum. This is what must be done in every civil commitment case, barring some like extreme exceptions, in order to say that you have constitutionally represented the client's interests. And then another set of standards under those base standards of, if you want to be the very best you can be at it, these are your best practices. So these are kind of your aspirational goals in most cases, and then your bare minimum goals in every case.
Jordan, can I hold on?
This is
weird. Stop. Don't. Why are you doing weird things? Update the entire table. Okay. Much better. All right. Let me share screen real quick. Ignore the fact that this is all in red. But this is to give you an idea of where we're headed. This is the kind of document that we're looking at. This is the draft for the dependency standards that are currently working through. It's got a little bit of the structure, so you can see like what kinds of standards we're going for. And the themes of what those standards are, right? So we've talked a lot about the role of the attorney, what communication is going to look like. There are going to be different things for civil commit, obviously, and the individuals, like the themes might be different, and the individual standards within those themes might be different. But the structure of the actual rules, we're looking at big standards. Those are what we would consider contractual obligations. And then best practices, which are refinement of those standards and other things that we want people to be doing, but they're more aspirational. They're like, this is where we think that representation should be driving. But some of them may be very difficult for us to enforce in a contractual way. Like for instance, with dependency, if you're representing kids, you need to speak with them in an age appropriate manner. How do we enforce that? That's not really an enforceable provision. So like there's some stuff that is going to be considered best practice simply because we don't have any real way of holding people to it. But there's other stuff that's going to be really, really core central aspects of how an attorney should be doing their job that we can hold people to, and that's what we're looking for as the standards. Does this kind of help everyone visualize what we're looking for? Cool.
Yes.
Okay. I'll give Jordan the screen back then.
Thanks, Kevin. I'm just gonna real quick pull the commission materials from the last commission meeting. I believe have the, yeah. So this has the, I said enter. There we go. So that link for the August 20th Public Defense Commission meeting has the criminal standards that have been published. They're not in the final adopted state, but they were published for discussion by the commission. And as we go through that, might give folks some other ideas onto what we're talking about. So I'm going to pull up our standards draft. With that kind of discussion in mind, let's do this. As far as brainstorming goes, what would you all say the minimum stuff you need to do, just kind of broad topics of stuff you need to do with every civil commitment case?
I think there's client communication, like preparation for the hearing. So reading the documents that are filed with the court, and also the record, your client's record outside of what is submitted to the court. If they identify helpful witnesses, calling them, or if they identify people that they want you to talk to, calling them and getting a sense of whether or not they're going to be helpful. Knowing, and then it's preparing for a hearing the way that I hope everybody would prepare for a hearing. So you have an idea of what you're going to argue, and you know what the law is, and you're familiar with the case law that is going to support. You're going to look for the case law that is going to best support your argument. And motions practice associated with procedure and stuff like that as well. And then in the actual hearing, all the same stuff that I would hope that we're all doing in our actual hearings, of like, say the stuff you're supposed to when you're supposed to say it, and object at times.
Okay. Two things. One, as a disclaimer, for any time I type on screen, spelling's not my forte, grammar's not my forte, but I generally go back and fix it, but please don't judge. Two, as far as broad topics, before we get into the kind of second level bullet points, I'm going to add post-hearing work, but does anybody else have any of the big topics that they think we should add?
I think included in investigation is also contacting the state's witnesses. And a typical civil commitment practitioner would know that that's at minimum going to include the investigator, the inpatient psychiatrist if they're inpatient, family, And if you are able to get a release outside professionals such as therapist, psychiatrist, etc., social worker.
Okay.
I'd include the examination process also
Yes.
as a, so you need to be involved in the examination process as a bullet point of itself.
The state's examination of the client? you
No,
mean?
so I would put no, there's an examiner that's appointed by the court that's meant to advise the court about whether the person should be committed. It's the examination is done differently, like widely differently, jurisdiction to jurisdiction. But the lawyer should be actively involved in the examination process. It'll look different depending on where your county is, but
Frequently that's contacting the examiner directly and scheduling
Mhm.
their out of court examination with them so that you're present with them and your client.
Mhm.
Okay.
There's also motion practice. Sorry, you got that. Sorry. You got motion practice.
Okay. Any other big bullets?
Coordinating with appellate counsel. We do that pretty frequently in this field.
Okay.
There can be negotiation as well.
And especially with the changes to the diversion statute, that will
Yeah.
be more important coming up.
Yeah.
Yeah.
You can negotiate on diversion, you can negotiate on outpatient commitment,
Mhm.
intensive outpatient treatment.
All right. So if that's all the big dots, let's back up to the top. Work on some of the little dots. What are the vitally important pieces of client communication?
In person, if at all possible.
Yeah,
Okay.
I think it's important, and I mean, I appreciate that we're going into this environment where we're going to need more people that can do civil commitment lawyers, especially in like outlying counties. But I think it's important that the in-person not be a best practice, but that be an expectation.
Okay.
I would agree. I've had an exception for people who are outpatient
Sure.
just for safety reasons more than anything.
Yeah.
So I have in our notes that one of the musts is for mental health commitments, if the PAMI is detained, in-person contact within 24 hours unless the
Yeah.
needs of the case require earlier contact. And if not detained, attempt contact to schedule initial interview within 24 hours of appointment. For IDD initial commitments and both mental health and IDD recommitments, in-person contact within 7 days.
That's good to me.
Okay.
And
is
Go
the
ahead.
term client or PAMI or
I think client
Both.
fine, like we understand it's our clients.
And it's not always a PAMI, it's sometimes
Right.
a intellectual or developmental disability or an extremely
Mhm.
dangerous.
I think making clear too that it's not just one contact. Like you're going to be in communication with your client throughout the duration of the case. So even if that's 3 days, like maybe you go to the hospital all 3 days to see your client and be in touch with them.
Yeah, I just have ongoing contact as necessary to prepare for hearing.
And keep the client informed.
And with diversion, our appointment continues throughout the 14 days of the diversion. I don't think you need to have everyday contact with someone on diversion, but I will casually check in with my client who's on a diversion when I'm at their hospital and make sure that, so as needed, check in with people who are inpatient on a diversion.
And I will note that the expectation that attorneys remain working on and in contact with their clients during a diversion is likely to be a culture shift in many counties,
Yeah,
and not a bad one.
I'm sure there's counties where they have no contact,
Yes.
even though the statute requires it.
Do you have people staying for the whole diversion period very often, Bailey?
I would say they don't usually tell me exactly when someone discharges. I would say it's not irregular, but I also frequently have people who are in for 3 days, 5
Yeah.
days, 10 days.
Yeah. It's so uncommon here for
We-
people to be there the whole 2 weeks.
It seems like it's relatively uncommon. And we also have this newer culture of day one diversion, which is, I would say, overall negative.
Yeah.
Because you're gonna have people on diversion who don't need it. On the same token, though, that means that those people are getting released on day 3 or on day 5 of, they might not have needed the diversion at all. So unfortunately, that's something we can't really challenge because there's, the challenge to it is have a hearing, which is extremely not beneficial for our client if they're gonna get out on day 5 anyway.
Can you just well, I guess because it says you have to go talk to them within 24 hours. I was going to say, can you just dawdle a little bit on the getting the paperwork back to them?
They initiate it without us submitting any paperwork back in our county. So I do submit a certificate indicating that or a declaration indicating that I reviewed it with them when I'm able. But they don't wait up on us giving a thumbs up. They only will respond if we respond within the 5 business days saying this person actually objects to the diversion, set a hearing within the 5 business days.
Interesting.
And they will.
I think
Xavier notes in the chat.
But I think we had talked about that's not really a reason to not have contact with your client within 24 hours. Like if the client's in Portland, then maybe somebody in Portland needs to be appointed if nobody from Douglas County can make contact with them.
Mm-hmm.
My experience down in
And I will also note that there are going to be counties where that is always until there's day 1 appointment across the state, which died this year, or day 0. That is always going to be one of the tensions here, is that we need to have the standard should really be in-person contact within 24 hours, but that is going to be a difficult thing to achieve for in some locations.
Xavier had something to say, and I think his connection is back now.
I apologize. In Douglas County, specifically, sometimes clients would be in Portland. You would just be assigned. It did not seem, from my point of view, that they really looked at your schedule so well. And you said, hey, go do this. I'm in trial, right? Okay. And so the contact within 24 hours getting up to Portland was challenging at times. And as we know, some clients' telephone contact was not really, not really feasible for some of the clients that I've had there. So I would just note that, if it is the expected thing to go in 24 hours, expected if, where reasonably possible, or exceptions can be made.
I think though
And
that's why we've been talking about the possibility of having someone appointed local to the hospital as opposed to, so for example, if someone's a resident of Douglas County, under the way we have it now, all of those appointments, as my understanding, goes to UVPD. But if someone's in Unity in Portland, it would make more sense to appoint them to a Portland area attorney or even Marion County, who can then travel to Douglas for the hearing, or alternatively remain up in Portland with their client for the hearing. That would be my preference typically, rather than having my client dragged down, 3 counties for court.
Venues.
I guess the other thing, sorry, Xavier, if I could, the other thing that might be important for the group of note is, from the agency's perspective, at least this was our tack with the criminal stuff, and I don't see any reason it's not going to be our tack with the other areas. We understand that some of the stuff that we're proposing as both the kind of baseline standards and the best practices are going to involve some shifts in practice and some shifts in culture. And these are not designed for someone from the agency to say, you're not doing this, bad lawyer. That's not the point. There may come a time where they are used in conjunction with kind of our quality oversight function, but at this point they are designed to say this is what people should be doing. And if there's a reason why in any particular case, or in a swath of cases, that it's not being done, that's going to be part of a discussion. It is not going to be a kind of, for lack of a better term, hammer. And one of the places this came up in the criminal context was the requirement that you see in custody clients, I think we put within 48 hours or 24 hours. And it's just well, what if I'm in trial? Okay, then you're in trial and you probably can't do that. But, that's an explanation that gets sent to us, and that's fine.
I think the culture shifting for these types of cases is also going to have to be done with the courts and how they assign the cases and what the communication with the lawyer is about the assignment. And I think it would be helpful if OPDC had a person who was going to be able to kind of make the rounds and explain, like, we have set up these standards, this is what we're expecting lawyers to do. And in order to be able to do that, you can't just appoint somebody. You need to have gotten confirmation from them that they're going to be able to do what they're required to do before you make that appointment.
Yeah, and I agree that's going to be helpful, and it's something we've been talking about, doing the rounds with everybody involved, from the attorneys to the judges to judicial staff,
And
and the groups, as far as an education package on the standards go.
These standards will go before the commission in the same way that the criminal standards currently are, and are open for public comment prior to adoption. And I mean those as two separate things. Putting them before the commission for commission review is one piece, and then separately, they are also on the website for public comment before adoption. And I would not be surprised if we also do some additional outreach with regards to these, so that it's a lot more clear that, yeah, some of these are going to be a culture shift. I mean, I think we are all aware that there is some problematic representation on these types of cases in various areas of the state.
And I believe the courts and the ODAA have weighed in on the criminal performance standards.
Yeah.
So both of those groups at least are aware of what we're proposing. Okay, so moving back to the kind of outline that we've got going here. I tacked in knowledge of and monitoring of legal changes or changes to the law. We'll figure out all the wording later. But that seems like, at least in recent times, something that's come a bit fast and furious for this area, or that may just be me as an outsider looking in. Is that something that happens with some frequency, or is that just this legislative cycle thing? I try to stay up to date on Court of
I wouldn't
Appeals
say
cases,
so.
and I don't remember a ton, but
No, I think the standard was established and, we've had kind of decades at that same standard until now. That's my
Yep.
perspective anyway.
Sorry, are we talking about the legislative change this session?
yes, and
Okay.
just kind of in general, is there anything we need to say specifically about keeping apprised of legal changes? Or is just a general requirement that someone is up to date on the most recent, law and case law?
I think mostly just that.
Yeah,
go
I would agree. I can't think of anything special. I mean, I guess there would be that, and also, I think best practices is trying out some of the arguments that or rather paying attention to the appellate attorneys and the items that they've identified as possibilities for challenges, things to preserve, and not just, I've reviewed the law and that's it, but also identifying areas for growth in the case law because there is a lot of work to be done in various areas. I mean, we don't have a definition of actual violence. It's a term that's used in the case law. We don't have a definition. And at some point, that's going to be an issue because I
Okay.
currently have DAs trying to argue that actual violence includes spitting. And I haven't had them succeed on that yet, but at some point, they're going to get something in as actual violence. That's clearly not. Especially with that is one area where the law change could impact things. Right now, it's, well, clearly spitting isn't actual violence, but that could be used to say, well, spitting could be a precursor to actual violence. And so now we're going to determine that this person is likely to commit acts of violence because they're spitting on people. So it's something to look out for, but that's just one little piece of where areas there are huge open holes in the case law right now.
That seemed like something you'd want a definition for.
You would think.
Yeah, I guess
Yeah.
along with that, the kind of ongoing practitioners, newsletters or emails or those kind of threads, staying up on those so that there's a better awareness of what goes on in other counties or how things might be interpreted differently or practices vary.
Right. There is a statewide meta that is really being upheld by Chris O'Connor. He's the one who sends that email out.
Okay.
For
Can we drop
hearing
down-
preparation, I think we could include prepping your client for testimony. Because my clients do frequently testify in their own hearings.
Okay. Is that a right they have, or is that the lawyer's choice?
It's their right. If I think they're
Also,
too
don't think you can
yeah,
prevent them from being called.
that's correct.
Like the DA can call, or whomever is prosecuting the notice, citation, the hearing, whatever. The whoever's prosecuting it can call them as a witness because it's technically a civil case.
That's correct. There is no right to remain silent. So if your client is capable of testimony, it's a good idea to prep them for it, even if you're not going to call them.
And I'm just making notes partly for me, for when we go ahead and draft these, and partly because we will probably want to have something about this in there. What else do we need to do in hearing preparation? What are the discovery rules?
It's complicated because while the rules of civil procedure apply, the timelines for discovery and the rules of civil procedure are impossible to comply with in a 5 judicial day timeline. There's also not much case law on this as well.
Yeah.
The counsel for the alleged is required to receive in a 5 judicial day regular PAMI situation. The defense is required to receive all records during the period of hospitalization within 24 hours of the hearing, or at least 24 hours prior to the hearing.
Mm-hmm.
My understanding, and I can be corrected on this, is we are not obligated to discover to the state those records unless requested. And even then, I think they have their way of accessing those same records without need for like a protective order or anything like that. It's already a protected proceeding. So my understanding is that we don't have a discovery obligation unless it's discovering statements of our witnesses, that like a written statement of a witness that we have. And same reciprocally with the state. I always, if I know that there's going to be a statement that they have in their possession, I email them, which is really the most formal discovery demand that we're able to do on such a short timeline. I email them to provide discovery of, for example, police reports that I know will contain statements of witnesses that are directly related to the incident.
Yeah.
In Marion, we also have, as part of our the standard order appointing counsel, included in there is an order for the treating hospital to provide us those records when a hearing is set.
Mm-hmm.
Because there are hospitals that are extremely difficult to work with in that regard.
Is that the same elsewhere? Is that just a standard court order, do we think, or is that a Marion County thing?
No, we have some kind of a standard, something that goes out immediately that gets records more easily than the usual discovery.
It became standard in Douglas County
Mhm.
After Bailey and I won like 5 hearings in a row because they didn't give us records.
Well done. Okay. Any practical notes for preparing a client to testify?
Really depends on the individual, honestly. There's so many different presentations of these various disorders.
Is there any kind of phrasing we could use? Like Kevin gave the example of communicating with juvenile clients in age appropriate language. Is there something we could frame like that? Communicating with clients in a way that's calculated to best be understood.
That is also dependent on what disorder the individual has, and further is often impossible for some aspects of what we're doing at times. I would say that many who are in the intellectual and developmental disability grouping will react similarly, or it would work similarly to representing many children or
Mhm.
juveniles, in terms of making sure that the language is, I think it's based on reading level, if I'm not mistaken. It can be, or it can be kind of created based on a reading level or an age group. But that also depends on the individual and what their disability is. And with mental health disorders, it really, you often have to adapt to that individual, because they'll frequently have like a paranoid delusion that you need to work around in communicating with them, or a severe disorganization that you need to figure out how to communicate with them. Many people do well with writing things down for them, especially if they have a memory loss issue. On the same token, there's others who writing things down is not at all helpful. So it's very dependent on what their struggle is.
Okay.
Having the knowledge of what their presentation is, I guess, is the best tool that I can propose someone should have, is having some level of idea of what the challenge might be. Although I'm often finding that out while I'm talking to that person.
What does that require as far as background knowledge?
I would hesitate to put any kind of educational component on it or anything like that. When I started doing this work, I had zero background. And this was at UVPD. We really didn't have that requirement. It was just, hey, you're available, jump in. And I think that I would like to see at some point somebody, and maybe this is just, I need to be the change I need to see in the world, developing more training on those kinds of topics. I've done a training on it before, but it was geared towards 370,
Mm-hmm.
how to communicate with and communicate about your client's mental health disorder and identify the symptoms that they're experiencing.
And one of the things that the agency hopes to use these best practices for is to develop trainings and training standards. So thank you for volunteering, or at least presenting a willingness to be voluntold.
I am willing to do, considering I've already done it for OCDLA, something very much adjacent. I'm happy to continue that line or collaborate with somebody.
Okay. What about as far as a best practice goes? knowledge of the DSM helpful, or
Yes, I would say having knowledge at least of which disorders qualify as qualifying mental health disorders, which the DSM does not specify. I believe it's in an OAR somewhere, if I'm not mistaken.
I think you're right.
Xavier had a comment. Release plan. Oh, yeah. Yes.
Good call. Would that be hearing preparation, do you think, Xavier?
Not to speak for him, but I would say so. Is that something you'll want your client to testify about?
Especially if they're alleging failure to meet basic needs.
Yeah.
I mean, it serves a dual purpose that way.
Just the ability for them to be able to say in court, if I'm released, I'm going to go to the shelter. I can get food there. I can get clothes there. I'm going to get my meds at this pharmacy. That kind of thing. Xavier, did you have something else to add?
I was thinking about it more, not just, for use at the hearing, but literally speaking, like when you win and your client is released in January in jeans and a t-shirt without any clothes, family won't take them because they're the ones that tried to have them committed, and they've got nothing. What do you tell your client? I mean, first time it happened to me, I'm like, I have no idea. And, so I developed for Douglas County like a 25-page booklet that I would carry around to hand to clients. Right. Portland's got some stuff like that, but it's something that's in my practice was very useful. Like, hey, here's what you need. Here's where you can go. So, but yes, also useful at the hearing. My client knows these things. This is what my client's going to do. They've got a place to go, a place to stay, a place to get food at. We've talked to their friends, their mental health, all those things. So yes, sure. Both as prep and best practices, maybe.
I absolutely agree with Xavier, and a step further from that is reaching out to those resources when it's useful to do so. Frequently, our inpatient clients will also have social workers that can do this, but I have found it helpful to do this work on my own. For example, when my client was committed, working with their shelter on making sure that their belongings were properly stored while they were committed. One time I walked a client to the UGM after seeing them on the street after being discharged. It's really important I think it's important for criminal defense practitioners to have knowledge of these resources as well, because in both of these fields, we have a significant amount of houseless clients or imminently houseless clients, and we should know where our local resources are. And engage a case manager if it's helpful, if we're considering they may not receive case management resources from the county.
Great. All right. So it's 12:50.
Yeah, I have to run to court.
I'm going to cut this here, Bailey. If you can stay for 2 minutes, I just want to give
Yes.
a quick heads up. So I think what I'm going to try to do for next time is start putting this into some draft language for us to review, and hopefully have that sent out to you guys ahead of the next meeting. That'll let us talk about the kind of draft language and then go through and figure out what else we need to add. If anybody has any questions or anything else, we can hang on for a few minutes and address those. If not, I want to say thank you to all of you for your participation and help, especially with our pending loss of Kevin. We really could not do this to any particular quality without you all.
Yeah, thank you.
Yeah, thanks.
So I'm going to stop the recording, and you guys will have a good couple of weeks, and we'll see you next time.
Thank you, guys.
Bye.